Did you know that your divorce decree will not revoke your will, your power of attorney, or any other documents in your estate plan? I'm going to tell you a little bit about that right now in this video. Hi, I'm Varvara Gokea, the founder of The Inheritance Lawyer. We create estate plans in order to protect yourself, your loved ones, and your assets before it's too late. This is what happened to Mrs. Smith. Of course, this is not her real name. And she came to our office to probate and obtain her brother's assets when her divorced brother passed away last year. Mrs. Smith's brother passed away in 2021. He was divorced for more than 10 years. He was a hardworking and very organized man. Mrs. Smith was the only surviving relative, the only sister. Her brother wrongfully assumed that his divorce 10 years before his death completely canceled all the documents he had created during his marriage. Mrs. Smith's brother didn't own a home because he gave the home to the ex-wife when he divorced her. Mrs. Smith's brother had an IRA. She knew about it because he was constantly withdrawing from the IRA, the required minimum distributions. The brother also had a stock brokerage account because he was fascinated by investing, selling, and buying equities in companies. And the brother also had a life insurance. Mrs. Smith didn't really know how much was the payable amount on the life insurance. Mrs. Smith listened to the brother, who always told them that they will inherit everything from him because they were the only relatives. Mrs. Smith had 3 kids, and they were wrongfully thinking that they're gonna inherit everything from the uncle, from the Mrs. Smith's brother. As he passed, Mrs. Smith came to our office to start probate proceedings for her brother's estate. We discovered that the ex-wife of the brother already had filed his old will with the surrogate court. You see, the brother wrongfully assumed that the divorce had canceled, had revoked the old documents created by him during marriage. The brother never met with an estate planning attorney to change his plan after his divorce. In his last will and testament, created during his marriage, the brother nominated his ex-wife, who was a wife at the time, as the executor of the will. Also, at the time of the marriage, he nominated the wife, now ex-wife, to be the designated beneficiary of the IRA and the designated beneficiary of his life insurance. Unfortunately, Mrs. Smith didn't have anything to counter the ex-wife's claim because the brother never put anything in writing. Mrs. Smith had only his words and only her beliefs that she is the only surviving relative. However, courts don't take words into consideration. So the lesson of the story is this: a divorce decree does not cancel documents that were created during marriage. This story teaches us that the minute we get a divorce, we have to meet with an estate planning attorney and make sure that all the designations have changed. Create a new will, create new beneficiary designations, and make sure that our wishes are in writing. Creating a new estate plan after the divorce will give you peace of mind knowing that no unintended people will inherit from you. Meeting with one of our attorneys, we will make sure that all your IRAs, your 401ks, your life insurance, your stock brokerage accounts, your bank accounts, everything will go to the people you intend them to go to. For this reason, we created the free inheritance audit meeting. This is a 15 to 30 minute meeting with one of our legal assistants when you will know if you have all the documents in place, if you are prepared for life on your own after divorce. I'm Varvara Gokea, the founder of The Inheritance Lawyer, and we invite you to call us now to schedule your free 15 to 30 minute inheritance audit meeting now.